This is one of those hearings where the real story isn't the shouting, it's the checklist. Because when a senior congressman stands up and rattles off a chain of DOJ moves that sound like anti-corruption is being dismantled, you're left with one question. Is justice being applied or managed? Watch the sequence, watch the timing, and listen for the phrase that tells you exactly how the public starts losing trust.
The Department of Justice announced that it would demote the Foreign Corrupt Practices Act and not bring prosecutions there. It sacked 17 inspectors general when it started, people who saved us a combined $91 billion last year in ferreting out waste, fraud, abuse, and corruption in the government. It pulled the plug on the corruption prosecution of Mayor Adams in New York after Mayor Adams agreed to engage in a political alliance with Donald Trump, which then prompted the resignation ultimately of 6 or 7 attorneys, including the U.S. Attorney for the Southern District, Danielle Sassoon, who was a conservative Federalist Society lawyer and a Republican. Her number 2 also quit, saying that you'd have to be a fool or a coward to give in to this kind of pressure. Then they decimated the Public Integrity Unit. They dismantled the Kleptocracy Unit in Department of Justice. They shut down other units focused on stopping foreign interference in American politics. Mr. Fox, why is prosecuting white-collar crime with specific enumerated offenses with the definite material elements in the crime, why is prosecuting white-collar crime important?
Yeah, so I looked, it seems like there's about maybe 7% or give or take of crimes that DOJ prosecutes. It seems like that will fall under the white-collar category. I think, there's a lot of the work that the federal government prosecutes are things that far exceed the doctrine of enumerated powers, or things that the federal government has absolutely zero business getting involved in. I think white-collar crime is one that arguably can fall under the ambit of the federal government, and it's something that is important to, discourage political corruption, make sure that people are, being prosecuted because the Department of Justice has evidence that they committed a crime, and they're not being prosecuted because of, what their political views are, or that they're not being let off because of what their political views are. People don't trust a system that targets people or that ignores people based upon the views they espouse or the people they support.
So do you think that undermines public trust in the justice system?
Oh, dramatically.
It sends out the message that we have this 2-track system, one for people who engage in kind of the run-of-the-mill state law crimes like assault or theft or robbery, and then one for white-collar criminals in the government or in corporations or in politics who are able to get away with it if they know the president or they know the right person.
Yeah, I think that's right. And also goes back to the question Ranking Member McBath asked, which is, about are they going to target people who they know will fight back versus won't have the resources to? So I think, that's all very related there.
Yeah. Have you studied the whole question of whether there is systematic inclusion of a mens rea requirement, so we're not putting people in jail for most regulatory offenses?
Yeah, so a lot of regulatory offenses, and frankly also a lot of statutory crimes, don't include a mens rea. The theft charge that I talked about before in the Moore and Mansell case, if I were to take Mr. Canaparo's water bottle and give it to Professor Turley, we're on federal property, technically I could be charged. That's preposterous. No reasonable person would ever think that's theft, but without an actual explanation as to what theft is that I actually intended to, take his wallet and bring it home with me, people would, they would absolutely, fall victim to these types of prosecutions, which dramatically undermines trust in the system.
Yeah, I understand that the chairman and I think Ms. McBath have this Count the Crimes Act, which suggests that we don't even know how many crimes we have. There's been such a radical proliferation of offenses throughout the federal code. But do you think it would be advisable for us, once we've counted the crimes, to propose a Cut the Crimes Act, where we get rid of a lot of the offenses that transform malum prohibitum regulatory crimes into real criminal offenses that most people would think should apply only to malum in se.
Yes, certainly. I know the chairman also has the Mens Rea Reform Act. I think those two things in tandem, if you set a default mens rea that way, we're not sweeping people into the criminal justice system over things they didn't know would be crimes. And then also, I'm not sure it's actually possible to count all the crimes, but assuming we can do that, then we're able to sort of come to a consensus as to what doesn't belong. But I would also say if we're not able to do that, there's other changes we could do. Like I have an idea that we could just inform jurors that they have the power to acquit against the evidence when justice requires. So in a case where the Department of Justice brings a charge like the case I discussed before, where any rational person would think it's absurd, the jury can be like, you know what, we don't agree with the defense theory, this is nonsense, we're going to acquit. And that's a power they still have.
And I yield back to you, Mr. Chairman. I don't want to commit a criminal infraction here by going over my time.
Too late.
Too late.
Yeah.
Okay, here's what you just watched. Raskin didn't come in with one accusation. He came in with a sequence, a checklist of moves that, taken together, paint a very specific picture. Anti-corruption enforcement getting deprioritized, oversight getting gutted, specialized units getting dismantled, and then the most explosive claim of all, that a corruption prosecution gets pulled after a political alignment. Whether you agree with every word of his framing or not, the reason this moment hits is simple. The public doesn't measure justice by policy memos. They measure it by outcomes. Who gets investigated? Who gets protected? Who gets consequences? And who gets a quiet exit? And that's why the witness's answer matters more than people realize. He doesn't have to sign on to every allegation for the damage to be real. He agrees to the principle. If people believe the system targets some and spares others based on politics, trust collapses. That two-track system line is the entire story. Because once Americans start believing there's one track for everyone else and another track for the connected, every case becomes suspect. Every prosecution looks like a message. Every non-prosecution looks like protection. And it doesn't just hurt one party or one president. It rots the legitimacy of the entire institution. Then the hearing pivots to something that sounds nerdy, but actually explains how selective justice becomes possible in the first place. Mens rea, intent. In plain English, it's the difference between you meant to commit a crime and you technically violated a rule. When laws don't require intent, or when the definitions are so broad that normal people can't even tell what's criminal, you create a system where almost anyone can be charged with something if a prosecutor wants to get creative. And that's the quiet danger. The broader and more technical the criminal code becomes, the more enforcement turns into discretion, and discretion in the wrong hands becomes leverage. That's why the water bottle example lands. It's not about that specific scenario. It's about the point. If the law can be stretched, it will be stretched, and usually not against the people with the best lawyers, the best connections, and the most political cover. So when you combine the perception of anti-corruption units being weakened with a legal environment full of technical crimes, you get a perfect storm. Powerful people get off-ramps, and ordinary people get traps. One set of rules for the people who know the right person, and another set for everyone else. And look, you don't even need a grand conspiracy for this to be corrosive. You just need enough quiet decisions that all point in the same direction. A unit here gets dismantled, a prosecution there gets deprioritized, an oversight role disappears, a standard gets relaxed, and suddenly the public isn't asking, what does the evidence show? They're asking, who are they protecting? That's the moment a justice system stops being a justice system and starts looking like power management. So whether you're watching this from the left, the right, or anywhere in between, this is the takeaway. The rule of law doesn't survive on speeches about integrity. It survives on consistency. If the public sees a system that punishes the weak and negotiates with the connected, they won't just lose trust. They'll stop believing the system is real. And once that belief is gone, it's almost impossible to win back.